is a matter which is important, although in its numerical sense it was trivial. We luckily had a taxpayer who used that English maxim, it's a matter of principle, and went all the way to the tax board. Yes, it's only the tax board, so it's of insignificant influence, but it is important nonetheless. And luckily we had somebody from SARS Legal who was willing to take part in this little play, and an advocate who was willing to draft a detailed review of the position and came to a conclusion in the tax board, all for 250 Rand, I think it was. It might even have been a little bit less. But it relates to an important issue that we all are going to come across in our day-to-day practices. We lodged this trust tax return. It was at the beginning of the e-filing process. And in those days, you could wait a year before you got an assessment. It wasn't abnormal or unusual. And we knew we only had to pay the amount of tax when we got our assessment and by the second date, because it was a relatively small amount of taxable income and this wasn't a provisional taxpayer. And then we come to the second year and we lodge our return, and instant gratification, we get the notification to go look in our e-filing postbox. And if you don't receive the knock on the door, you don't go to the postman and look in the postbox. And in our office with some 6,000 clients over all the different years and the different tax types, we can't go every single day and look in every postbox. We have to wait for the notification. And we got a notification for the second year, but there was no notification received for the first year, although when we got the second year and we went to the postbox, we saw there was a balance in the account. And so we objected on the basis that that assessment could not be deemed to be valid in that it was not delivered to us. And to merely put it in our postbox on e-filing in cyberspace is not delivery as required. And we won in the tax board for our paltry 253 Rands worth of interest, and it was reversed. But many of us have the episode of getting an assessment that we never got the first time, and then we're late for everything, and we're on the wheel because we're late for the 30 days, we're late for the 21 days, and yet is it a valid assessment? So yes, it was a tax board matter, but we got a detailed judgment, and it's an important matter to highlight for us, so that even in the back of your recess of your memory, you know, if you haven't received that notification and you didn't look, and then it comes into your postbox later, you can deal with the matter. There is some hope at the end of the tunnel. Now, pay now, argue later. That's the great bugbear that we all have to deal with. But it's been hard fought that we have enacted Section 164 in the Tax Administration Act. That's the legal basis giving us the ability to request the suspension of payment pending objection and appeal. And it's a senior SARS official that must no in order for it to be binding, and as was indicated earlier, we don't have the comprehensive list, so if you're in doubt, you must make them show that they are a senior SARS official if the answer is no. And you've got your 10 business days if they can count to 10 before they are meant to take any action. Now, it's not an inherent right that you have that all objections and appeals will be subject to suspension. You have to meet criteria, but at least we have some sort of a framework of issues that we know we must address for consideration. As I've said, they should have put 164.3a on a all by its very self, because they regard that as the be-all and the end-all of the decision-making process, but it isn't. It's only A in a list of A to H, and we must deal with it, and if we have some warts in that regard, we must put them out there on the table and show what the problems are and why those are problems and why they should not impact upon the decision, so that if we get an adverse decision, we can then make a conscious decision about either seeking redress through the courts or redress through the tax ombud, or revising our initial application and putting in a new application, maybe with additional security, maybe with some form of a lump sum payment up front, but we can revise and redo an application in that 10-day period, and hopefully they'll look at it again. It's not formally clear in the law whether there is a objection type process for a resubmission, but we do know that resubmission does work at times. They don't regard that in formal legalese as a functus decision. They do look at it again if you give them additional information in the new application. If you don't lodge the objection, if you don't lodge the appeal, if there's a change in your status during that period, they can withdraw that suspension of payment, but until such time there is a suspension in place. And if they look at it and they see during the period that you're being vexatious and delaying the process and there's no grounds to your objection, they can withdraw that suspension. That's the critical section 164.6, and when they say no, they must count to 10 business days before they act. That should be reminded to them when you make your application for the suspension of payment, so that they are aware that you are aware of your rights. But if you don't do the objection, if you don't do the appeal, if it's disallowed as part of the process, these things can be withdrawn. So what we're generally doing, we're doing a first request for suspension at the objection stage, doing a second at the appeal stage. If the amounts are material, we might lodge the request for suspension prior to us either having got the reasons or drafted the request for reasons or drafted the objection, in which case we'll indicate that our intention is to lodge an objection in a timeous basis, but we first are going to ask for reasons. We haven't formulated all the reasons, but these are some of the reasons that we're going to be looking towards, and these are some of our grounds of objection, so that the person considering the suspension can see the merits of the case, and we need to get that in early, especially in the critical months when the collection people are going hysterical for money. Now, the current rules as they stand, although the numbering will change, although the ordering will change, the key pointers of the current rules will still flow through into the new rules and are important to highlight. So Rule 3, that's the request for reasons that comes through, and that you then suspend the objection process until you have your reasons. That means that the SARS official has to do some work in giving you their reasons, and they don't like doing this. And that's why we have been requesting as the professional bodies that there's an actual button put on e-filing, so it's part of the e-filing process and monitored by the superiors in the system to see how many reasons are outstanding by SARS. At the moment it's done on the side. You send it to the relevant auditor, and there's nothing on the system clearly that says that you are requesting reasons, and there's no clear way for management to make sure that the auditors are actually giving you those reasons. I had questions about people being turned away at the branch because they don't want to do the request for reasons. Well, it's not a question of want to, it's an obligation upon them to do so in terms of the rules. If they're not doing it, these matters need to be highlighted to the professional bodies, and one needs to follow these things up once again through potentially the SSMO, the branch manager, the ombud, or Rule 26 as an ultimate weapon on the more substantial matters where you need the reasons. And one must remember that if you're not willing to pay the assessment, then ultimately all of this can become a problem when you've got that big tender and you need a tax clearance. So that 200,000 Rand matter might actually need a bit of a kick unless you're going to write out a check for 200 grand in order to get your assessment. Yes, there's the provision if you got a request for suspension that they should give it to you, but the law and the practice are unfortunately still a bit a world apart. So it is important to make sure that one keeps a handle on these issues. But our time to lodge the objection is suspended, and they have defined time frames in order to reply to our reasons. It's not an open-ended request, although we have had one matter in Durban where they took 3 years to give us reasons. This was before I worked on Rule 26 and made that my campaign. Rule 4 is the basis for which we lodge the objection, and we need to make sure we've covered the criteria. That's why we said in the practice note earlier, it needs to be signed by the taxpayer, or you need to give the proper authorization that you're signing on their behalf, and the timing of delivery. All of these things affect the validity as well as the right mechanism, the NOO for matters on e-filing, the ADR1 for matters that are not yet on e-filing. And the Commissioner needs to make a decision on that objection. And once again, he's got to do that in a time frame. He's entitled to ask for additional supporting information in respect of your objection, and you'll need to provide that also within a time frame. This is because, remembering, we don't have our brown official Amptelik folder that's floating around. It's what is or isn't on e-filing, and they need to see sufficient information to make their decision. They're meant to ask once for that additional information, but in reality they might ask more than once. They're meant to ask clearly at a defined time. They might ask later than that defined time, and this is you'll need to use some judgment about providing it more than once or outside of the time frame. Generally, it's important to give the information if you want the matter resolved at the objection stage. You can take some cheap points on timing, but then they'll disallow the objection. You'll end up in the more expensive appeal and ADR. So the more that you can resolve at the objection stage, the better. And if this requires you to give additional supporting information, then one must do so. But afterwards, SARS has a defined time frame to deal with the objection. And if they don't, then you've got the various avenues to make sure that they are adhering to it. And even if you're not going to take those avenues yourself, when SITE asks you for comment on time frames, on problems with your local SARS, give a detailed listing of cases with tax reference numbers where SARS is in default of the rules governing objection and appeal, where they haven't given you reasons timely, where they haven't resolved the objection timely, when they haven't resolved the appeal timely, when they haven't heard the matter for ADR timely. SITE needs that information in order to properly address SARS at the various meetings. So after this, and you've had now Rule 6 gives our basis of the notice of appeal, and this must clearly indicate which of the grounds in objection we are still relying on. And that's why one keeps the matters alive. You're relying on all the grounds that were set out in your objection, but you will amplify various matters as dealt with in the SARS notice of disallowance to give them additional information. Does it sound all right? To give them additional information to make sure that the matter is then dealt with at that stage. Rule 7, that's the basis upon which the ADR process starts. One of the issues is the agreeing on terms of the ADR. No punching, no kicking, no biting. All of those sort of things are part of the terms. You sign that on the ADR 2. You tick boxes on the NOA. But really what goes at ADR is meant to stay at ADR, except we have one Natal case where they tried to raise some things in the Pinetown Magistrates Court, and SARS took a little bit of a beating because of that. But in general, the matters in ADR stay in ADR. You hopefully resolve it. There's a period in which they're meant to both resolve it and hold the ADR process. Unfortunately, these things are generally delayed, especially if the matters get referred to head office. They take one set of time frames in the branch, another set of time frames to get it to head office, and yet another set of time frames when it's in head office. But at least there is something to bring them to account if they are in that process. The facilitator will generally be a SARS official, not directly linked in the matter. We've had no issues. We've had one issue in all the years where we regarded as a conflict, and that facilitator we wouldn't accept again. But in most matters, the facilitators have been useful in resolving the matters. The only problem with the process is that you think you have an agreement at ADR, but you don't necessarily have an agreement in ADR because it's still got to go through a ratification process. We are trying to get them to build that properly into the rules, in the new rules, because we know they have to have a ratification process. But don't say it's agreed at ADR when it's not really agreed at ADR. It's agreed in the ADR process and its ancillary processes. The reservation of rights, that's quite clear, and the settlement that comes out of the ADR process can sometimes deviate from tax law and properly, but it is in order to resolve the matter, especially when neither side has the strongest possible case. The hope is that you have two unhappy people leaving the ADR process and you've got the closest thing to the fairest settlement. It's not meant to be a win and lose. You are meant to go and give up something for the greater good of resolution, because this is still far cheaper. Even the cost of giving something up is far cheaper than the court process. That's a very expensive process once you're on the treadmill from Rule 10 upwards. You want to stay off that, and you want to resolve as much as you can in the ADR process. SARS then have to report internally their ADR processes and their results. And when you're not successful in ADR, or you're partially successful in ADR, then you move on to Rule 8, and you're appealing to the tax board. And this is where we as accountants are starting to get a bit of a wobble, because this is not an area where we like to be. We like to resolve things earlier at ADR or before, but we need to know that this route does exist, and we can go and represent clients in tax board and even in tax court, but it's not the place that we generally want to be. This is where we need to start using our professional judgment to bring in an attorney, to bring in an advocate if one is starting to go down this road. And we go just a little bit further, but we are now assisting somebody in the process. This will be now the legal process, the limitation of the issues in dispute. For instance, if it is a general deduction formula dispute, are you being required by SARS to prove all the components of the general deduction formula, or maybe just actually incurred, for instance, or in the production of income, for instance? Maybe it can be limited to which of the criteria you have to prove. That's limitations of issues in dispute. And thereafter, we move into where we started at the beginning with Computech, to Rule 10 and Rule 11. Rule 10 is where Commissioner sets out his grounds of assessment, and Rule 11 is where we set out our basis of the appeal. And under the new rules, the order of 10 and 11 may very well change. At the moment, SARS raises an assessment, we object, ping pong. They do a notice of disallowance, we appeal. Then they do Rule 10, we do 11, then we stand up in court and we go first because we bear the onus. And SARS is saying, well, 10 and 11 are actually inherently part of that court process. So you must go first in 10, we will go second at 11, and then you'll have a right of reply in 12. All the numbers are going to be completely different, but that's the conceptual framework. And we've argued to SARS, that is going to mean that we have to make sure we've got all the reasons so clearly at the Rule 3 stage in order for us to do the objection, because we are limited in our Rule 10 as to why we are appealing, and we need to know the reasons. And that's going to put undue pressure on your stars, because they are going to be bombarded by every practitioner requesting reasons, which is not the case at present. And that's where we are in this impasse with the third version of the rules, which, even if they accepted in that version, will first have to go to the Department of Justice. So in December we thought the rules were coming out in January. In January we thought they were coming out in April. In April, I don't know, maybe in August. But the new rules may still come through another round of consultative process. And that's why the decision I made was to focus on the basics of objection and appeal and the rules as they stand, so we can get a foundation going forward. And after Rule 11, we're all getting very phasey now, because this is not our area of comfort at all. We're now dealing with issues in appeal. We're dealing with amendments to grounds of appeal. And that's when I'm stopping, because now we are purely in the legal framework of the dispute, who the witnesses are, what the disclosure must be, what the discovery must be, what the timetable for that legal dispute is, and that's not where we're in charge. What we have here in the new rules is maybe a change of that whole focus. But what's important for us to know is that Rule 26, there's a big gap until we get to Rule 26, does exist. We've covered that in detail, where we're having problems with SARS adhering to the time frames set out for objection and appeal and the reasons. We've got the ombud as another mechanism to hold SARS accountable, and we've got the professional bodies who need your input for issues that are key and at stake. So that's